warrant on Marion inmate was actually executed. Just want to make sure he's okay with that. Something to rescind because they lost the document. Okay, okay. Is he okay with that? Okay. Yeah, I'm the only one here. Been there, done that. It's all good. I just want to make sure he was okay with that. Okay, good. Okay, bye. Oh, looking for Chris. Can you just get, no, just give him a message for me. Tell him I tested the phone and you don't dial now. For the phone, yeah, for this big conference phone. I just tested it to see what the story was. So we just don't dial 9 because we were dialing 9. Just so he knows in case he's down here again. I put a little sticker on it. It's in the courtroom. He'll know when you tell him that. Okay. Okay, bye.
You are in the Zoom meeting We're just waiting to get all the people here. Can you hear me?
Yes, I can.
Okay. I'm going to try and avoid having a lot of. Sherry, can you say something just so we can make sure that they can hear it when the judges speak?
You need me to call for the judge?
I can hear you guys.
Okay, when we use this, okay, for our records and for the corrections officer, when we use this booth, there's a lot of echo. So I'm going to try and use the other booth for the rest of the week if possible.
Sorry, Your Honor.
For the rest of the week, I'm going to try and use the other booth. It seemed to work better and not having this echo.
There's a lot of echo in here.
A lot of echo, yes.
All right. Let me try to.
Thank you.
How about now, Your Honor?
Sherry, how's it sound to you?
Is this better or is there still too much echo?
Can we turn it down just a smidge?
Is that better now?
Yes.
All right, I had the volume on the TV that was in here. It didn't need to be on at all.
Much better, thank you. All right, I'll get everybody. I'll try to get the judge, and we're just waiting on the one attorney. Sherry, what courtroom are we using?
Jason, are there other matters I can go get some court dates for? Or is this our only case left for today?
This is our only case left for the day. What courtroom are we in?
And courtroom Given Dog.
Judge is on his way.
I did not have a sheriff's officer for the previous proceeding. I assume I don't need.
Okay.
Hi there. That's where I'm supposed to be. All right. Yeah.
Hi, Judge.
Hey there.
We're just waiting on Mr. Roddy.
Okay. I thought this was Miss Bezetsner, Rosenblum, no?
Matisse.
Miss Batten? I thought this was a conflict because it was Miss Rosenblum's matter, no?
Judge, can you hear me?
I can hear you, yes.
Okay. It's a conflict because Ms. Rosenblum represents the victim,
Oh, the victim, okay.
and there's ongoing family court matters that'll be referenced during the proceeding.
Okay. Of course, we're waiting on Mr. Roddy.
Ally, just push the button. The big round.
Right. Bring them back.
Judge, I just texted you a status update.
Okay, hang on. Do we lose Ally? Are you going to be populating the order or no?
Me?
No?
Usually Melissa does that,
All right, Ally can do that.
or we're accustomed to whatever.
I've never done them here before. Well, Ally will take care of it.
Take care of it.
Yeah, let's make sure.
To get in the store, there's a big button she has to push.
All right.
I think she needs. There's a big.
We're just experiencing a little technical difficulty.
Okay.
This is the next 2 months. It'll get better. Summertime is coming.
They don't have the hard copies of the orders down there, or do they? They don't. That's okay.
Usually there's one per area.
Yeah, that's usually the case.
Judge, we're having technical difficulties.
Huh?
I got Mark Roddy on my cell phone on speaker. Can you hear Mark?
Talk, Mark.
Hello, Judge. How are you?
Yeah, I hear him well enough.
Good enough.
Does the jail hear him?
Yes, I hear.
Okay.
Okay, we're here on the record in the virtual courtroom in the matter of State versus Kyle J. Matisse. And this is warrant number 2020-38. May I have appearances of counsel, starting with State, please?
Good afternoon, Your Honor. Brenna Batten on behalf of the state.
Mark Roddy for Kyle Matisse.
All right, thank you. And Mr. Matisse, you're before the court for something called a detention hearing. The court is going to make a decision as to whether or not it should release you while this matter is pending trial or other resolution. I've reviewed the following documents which are in evidence. The complaint warrant, preliminary law enforcement incident report, probable cause affidavit, and I've marked them as S1 and as S2. I have marked into evidence a public safety assessment. And sir, because you're coming up on the screen somewhat small, I'm going to ask you, just so I can make sure you understand me or not, just give me a big thumbs up if you heard everything I said. All right, well, 2 means you really heard everything I said. I'm going to tell you some rights that you have to understand before I start this hearing. You have the opportunity to testify. You can present your own witnesses. You can cross-examine witnesses. You have the right to discovery. As I said before, this doesn't decide whether or not you're guilty or innocent. It just decides whether or not you should be held while this matter proceeds. If you do choose to testify, your testimony can't be used against you as to the issue of guilt or innocence. It can be used, though, if I decide to release you and you fail to appear or you violate any other conditions of your release. It can also be used in a perjury proceeding if you testify untruthfully. And finally, it can be used to impeach your testimony if you testify today and you testify differently down the road. Do you understand those rights as I've explained them to you?
Yes.
Okay, very well. All right, and I'm going to start with you, Mr. Roddy. Is there going to be a stipulation as to probable cause, or are you going to hold the state to its proofs?
No, not in this situation, there isn't.
All right, I'll hear from you with respect to probable cause. Ms. Batten?
Thank you, Your Honor. Before we, I get started on that, I did email counsel yesterday and the court prior to realizing the switch in the judges. I am going to be also referencing throughout the proceeding the amended restraining order that the victim has.
I don't have that in front of me, but I'll accept your representations on the record.
Okay. I can email it if Your Honor prefers, or,
We're in the hearing now. Let's get
okay.
started. Should have contacted us to find out if we received it ahead of time. Please move forward, Ms. Batten.
Okay, thank you. Your Honor, complaint warrant 38 out of Upper Township alleges that on March 12th of 2020, this defendant did purposely or knowingly endanger a child by creating a dangerous environment while in custody of the child. Specifically, this defendant disregarded law enforcement commands during the course of the serving of a restraining order, which resulted in the need for law enforcement officers to make entry into the home. Once they were inside of the residence, the defendant continued not to comply by resisting arrest. So he's charged with a second degree endangering the welfare of a child. That child is his son. Count 2 of the complaint charges this defendant with refusing to comply with the verbal commands and placing his hands under his chest, resisting arrest. And there's also an obstruction charge by this defendant preventing law enforcement from performing an official function by means of physical interference and obstacle, and refusing to identify himself and open the door to the residence during the serving of the restraining order. Your Honor, this matter, with regard to the affidavit of probable cause, on March 12th of 2020, Brittany Roper, she went to the Woodbine station to apply for the temporary restraining order. In speaking with her, she had mentioned that her child's father, this defendant, identified as Kyle Matisse, had been physically and emotionally abusive to her and the child while the family was living in California. They returned to New Jersey together, at which time she decided to apply for the restraining order to protect herself and her son. Her son was with this defendant, and she went and got the restraining order. As a result, when the officers went to serve that restraining order, the defendant refused to comply. A provision of the restraining order was that the victim, Ms. Roper, would have the temporary custody of the child, who's, I believe, a 3-year-old boy with the initials BM. They went to serve him. The defendant refused to answer the door of the residence. He made contact through a window. While speaking with him, the officers were able to observe the 3-year-old in the living room with another male. At some point, this defendant removed the child from sight of the officers, refused to open his door in order to discuss the pending matter and be served with the restraining order. Along with service of the restraining order, the police were going to hand over custody of the son to his mother. After numerous attempts to compel with the opening of the door, the officers ultimately made entrance through the window. The defendant was then being placed under arrest for obstruction. At that point, he was refusing to comply with the orders, at which time he was brought to the floor. During the attempt to arrest, the defendant held his arms underneath of his body and continued to resist. By refusing to allow service of the restraining order and the transfer of the physical custody of BM, this defendant created a substantial risk of harm to BM in light of having removed him from the visible sight of officers and forcing the officers to break through the residence through a window. At that point, there could have been injury and a substantial risk of injury or harm to the minor child. That child was ultimately secured and turned over to his mother. All of this was captured on body cam. That's all been turned over to defense counsel, along with the written reports and the restraining order itself. So as to that, the state would submit as the probable cause.
Mr. Roddy, is the probable cause just that issue?
I will address probable cause. Okay, the whole thing's on video, so it's not like we're not looking at 2 different videos. The police apparently are serving a temporary restraining order. They go to the house, they knock on the door. The defendant wants to know what they're there for or why they're there. They say, well, open the door, let us in, and we'll discuss it. He says, well, am I under arrest? And they say, well, no, you're not under arrest. Well, I don't want to open the door. They go back and forth like this for some time. Then the officer says, well, you're not under arrest now, but you're going to be for obstruction if you don't open this door. And he says, well, do you have an arrest warrant? Do you have a warrant? He says, no, but you're going to be under arrest if you don't open the door. He doesn't open the door. So the officer, now intensely angry, takes out his baton, smashes the crap out of one of the front windows of the home, rips the window out of the frame, and climbs through, jumps on the defendant, and yells, "You're resisting," while two officers are like crushing him to the ground, and then they arrest him. Only after that do they tell him what was going on. They never told him, we have a temporary restraining order. All you have to do is step out here and sign it. They didn't have any legal right to do what they did. They should have told him why they were there, which is their obligation. It is not an arrest warrant or a search warrant. It's service of a civil document, which doesn't even require a signature. They could have left it on the front porch and said, call us after you read it. There's a state Supreme Court case that was decided a year ago, State v. Fede, F-E-D-E, which says simply doing nothing, like not opening the door, is not an obstruction. There's a Supreme Court case right on point. But they insisted that they weren't going to tell him what it was about. They wanted him to open the door. He didn't open the door, and so they smashed through his window. I thought I was looking at some, 1934 film from Germany for a moment. But anyway, that's why I say that there is no probable cause. There's a state Supreme Court case that says that's not an obstruction. I didn't see anything in the video that looked like resisting. I see two cops jumping on the back of a defendant, and the child was in the care and custody of another adult and didn't start crying until the police smashed out the window and were climbing through it. If anyone should be charged with a child endangerment, it should be the cops, not the defendant. Everything was fine until they showed up. Now, if they had just simply been professional about it and told him why they were there, what it was about, he would have complied. Because after this is all over with, you hear them saying, well, why didn't you just tell me all this before? But they had no good answer for it. So I don't think there's probable cause for any one of the complaints. I don't think he did a darn thing wrong, frankly.
Anything else you wanted to add, Ms. Batten?
I'm sorry?
I'm talking to Ms. Batten. Are you done, Mr. Roddy? There's a probable cause.
Your Honor, the only thing I would add is that it was service of the restraining order, and a condition of that was that the child be placed in the custody of the victim on the restraining order. So this was not a situation where the police could just drop an order off in the mailbox and walk away. I mean, there was a child involved.
All right. Anything else, Mr. Roddy, as a probable cause?
They had an obligation to tell him all of this ahead of time so he could have made an informed decision about what he was going to do. They did not. They just kept insisting, we'll talk about it when we get in there. That's not how it's supposed to be done.
Okay. All right. So with respect to probable cause, the standard is very light. The Supreme Court describes probable cause as a well-grounded suspicion that an offense has been committed. The court does find that probable cause exists based upon the affidavit of probable cause, which indicates that on the date and time in question, the officers appeared at the home where Mr. Matisse was and where the child was to serve a restraining order that had previously been issued by Judge Luis Velasco. And it indicates in the affidavit of probable cause as follows. Upon attempting to serve Kyle Matisse with a TRO, he refused to answer the door of his residence and would only make contact through a window. While speaking to Kyle Matisse, I observed the child BM in the living room with an unidentified white male. Kyle Matisse was advised that he was required to open his door in order to discuss a pending court order. So that stands in stark contrast to what has been represented on the record by Mr. Roddy, that he was informed why they were there. Kyle Matisse refused to open the door and moved his son into a separate room with the unidentified white male where he could not be seen by troopers. And again, I'm reading off the affidavit of probable cause. After numerous attempts to compel Comatis to open the door, troopers made entry through the entrance, into the entrance through the living room window. Comatis was advised he was under arrest for obstruction and refused to comply with orders, at which time he was brought to the floor, and that he continued to resist arrest. So the court does find probable cause exists to support each and every allegation of the complaint warrant. I will hear from you with respect to the issue of detention, Ms. Batten.
Thank you, Your Honor. The state filed for detention of this defendant as there is serious risk that the defendant will not appear in court as required, will pose a danger to the victim and or the community, and will obstruct or attempt to obstruct justice. Your Honor, I'll start with the obstruction portion first. I mean, this whole incident arose from defendant not complying with law enforcement with regard to the service of a restraining order. And so in attempts to thwart that process, we are here now today. With regards to the risk of flight, this defendant does have known ties to California and is known to travel back and forth between California and New Jersey. So there is the potential for a risk of flight if released. But most notably with regard to the risk of danger that this defendant presents to the community and the victims in general, this restraining order that was filed initially on March 12th, 2020, it's under docket FV 05000360-20. In there is documented repeated abuse that this defendant had committed on the victim of the restraining order, Brittany Roper.
Right, but that's an ex parte restraining order that this defendant had no input into whatsoever, correct? And he wasn't even served with that order at this time.
Correct, but it goes to the underlying danger. Clearly there was an issue and there was a risk. There was findings made by the court, but most notably that restraining order was put in place. The child was then given, the custody of the child was given to Ms. Roper at one point after the service of the restraining order and the defendant having been incarcerated. Ms. Roper returned to the residence to retrieve clothing that belonged to the 3-year-old. At this time, Ms. Roper had been living with the defendant's parents, and the defendant was living at a separate residence. So when she went to pick up the clothing of the child, there was a handgun located on the bed in plain view as a result. And this victim also made it known to law enforcement and the court that this defendant did have access to firearms. There wasn't on the initial TRO, the search warrant to search for firearms. The TRO was later amended, and there was also an extreme risk protection order that was filed against this defendant with regard to his access to firearms. Ultimately, there have been firearms that were retrieved from the residence of the defendant, which is of concern with regard to the danger that he could present to the community and the victim.
Were they living together here?
I'm sorry?
Are they living together here in New Jersey?
They are not. They have been somewhat separated. However, this defendant has made comments to the victim, which is documented in the restraining order, that if she were to try to leave, she would never leave alive. And there has been a history of physical and emotional abuse. So when it comes to the Ms. Roper, there is no set custody agreement in place between the parties. So it's clear that this defendant has some sort of control over her. She came out here from California with Mr. Matisse, but when she's here, she stays with his parents, and he is at a separate residence. So while there's not an ongoing dating relationship, these parties are definitely intertwined when it comes to, the child they have in common together. So there are a couple orders in play that are against this defendant with regard to the ERPO and also with regard to the restraining order. There's, the risk that the non-compliance with the service of the restraining order led to the fact that this child could have been harmed in the process of that. So it's not under actual harm, it's under the risk of harm this defendant posed to the child. And like I said, with the ties to California, the documented history that's in the restraining order and also the extreme risk protection order that's in place and the recovery of firearms from the residents, the state would submit to Your Honor that this defendant presents, really he hits on all the triad, the obstruction, the danger to the community and victim, and also the risk of flight. And so it asks that this defendant be detained pre-trial. When it comes to the public safety assessment, I don't want to miss that. This defendant, the recommendation is released on their own recognizance, but I don't think it necessarily encompasses, the danger and everything that this defendant presents. He is a 2 for a risk scale on the failure to appear. He is a 2 on new criminal activity. He's 32 years old. He did not have any pending charges at the time of this offense. His prior history is from 2011 with the disorderly person's possession of marijuana. The restraining order isn't documented on the PSA. It was obtained. I don't know why it's not on the PSA. It was obtained previously. Normally there's a domestic history, but outside of that, if Your Honor has any questions, or I can always respond to counsel's arguments, but the state would urge this court to detain this defendant pretrial.
Thank you, Mr. Roddy.
Judge, I think the assessment is accurate. He has no real criminal history. He has no failure to appear anywhere for any reason. He has no felony convictions. There's no reason why he should not be released. The purpose of the Bail Reform Act was to encourage the release of defendants on non-monetary conditions so that they could come to court without having to put up a family fortune with a bail bondsman, which is what was going on before the statute was enacted. The state creates this monstrous scenario that the defendant is like the devil incarnate or something, but I would note that the assessment suggests release. Once the defendant knew about the restraining order, there was no suggestion he wasn't going to comply with it. It's very interesting that the alleged victim goes back later and claims she finds weapons. No weapons were found when he was arrested. No weapons were there, according to the other gentleman who was an independent witness in the case, the one that was holding the baby. Pretty interesting. There's no weapons on the day this occurs, but magically weapons supposedly appear days later when she goes to get some clothes.
Well, there's no warrant either.
Let's get back to the original issue. Is this gentleman a safe risk to appear in court when he's supposed to? Frankly, he is. The assessment is accurate. He doesn't have a history of non-appearance. He's never failed to appear in any court for any reason. He has no felony conviction. And as far as a danger to the victim, there's now a restraining order in place. If he would even think of violating it, trust me, I'm sure they would be down in the courthouse in a second. So that protection is already in place. It hasn't been shown he's a danger to anyone else. I have independent witnesses that said they spent the day in Ocean City with friends, that kids played together, that later on in the day he was constantly texting her, trying to get a hold of her to see if he could drop the child off so she could have him for the evening. I know it's a widely difference of opinion as to actually what's going on here, but if you look at the actual facts of what occurred, there's no reason not to release this gentleman.
Anything further, Ms. Batten?
Your Honor, just that the handgun was found on the bed of the defendant when the ERPO was carried out. I guess the search warrant reported the ERPO. There was no search that was done of the home that evening. The activity was mainly focused around the living room area. The police didn't have a search warrant through the temporary restraining order to search the house for weapons. So to know that there wasn't any weapons found that evening, it's because they weren't being looked for and they didn't have the authority to search.
Anything else, Mr. Roddy?
Now, if either Ms. Brenna Batten or myself were there, maybe we could testify personally, but I've talked to the one gentleman that was there, and to the best of my knowledge, there were no weapons anywhere.
All right, the court's ready to decide this. So I'm not going to deal with the issue of probable cause. Again, we talked about that already. The court did find probable cause, but the court finds that the state has not satisfied any prong of the triad by clear and convincing evidence. And I'm going to deal with each of them in turn. First, that no amount of monetary bail or conditions would reasonably assure defendant's appearance in court when required. No history of non-appearance whatsoever. As far as I can determine, he's now living in New Jersey. Protection of safety, I'm going to deal with protection of safety of any other person in the community last. Obstruction or attempt to obstruct the criminal justice process. We're told under the case law, under SN and other other such cases. And obstruction deals with whether the defendant has a history of bail jumping, witness tampering, and the like. So court finds that that has not been established. With respect to protection of the safety of any other person or the community, all we have here in terms of his criminal record are these charges and a temporary restraining order. There are no charges of assault with respect to this victim or of the child. And the court cannot detain somebody unless it fits within a certain category of crimes, which this does not fall within, unless there is more than just this offense. And that's the Hippolyte case. If just this offense in and of itself is not enough to overcome the presumption. So the court finds that none of the elements of the triad have been established by the state by clear and convincing evidence. I'm not going to order that the defendant is detained. I will hear from you, Ms. Batten, with respect to the conditions of release.
Thank you, Your Honor. And ask that with regard to conditions of release, the defendant not be allowed to have any contact with the victim, that the defendant have to abide by all family court orders. I know there's going to be a final restraining order coming up.
Well, there's going to be a hearing for one. You don't know.
That's what I mean, the hearing for the final restraining order. But I'm saying if there are further conditions that get placed upon him through the family court, I would just add compliance with family court orders. I don't know if there's DCP&P involvement at this time. If there is,
ask you next. Have you contacted DCP&P because you're aware now that the child was there at the time that the officers placed?
I know that the officers contacted DCP&P on the night of the offense.
No contact has been made, at least.
I know contact has been made. I don't know what, if any, conditions have been put in place.
Okay. Any other conditions that you're seeking?
No.
Mr. Roddy, do you want to be heard with respect to the conditions of his release?
No, that sounds fair. I mean, he's got to comply with family court. He's got to do what he's supposed to do, and they'll make those decisions. So I don't have any issue with that.
All right, so you're going to be released today. I'm going to go through the conditions of your release. I just want to make sure you're still hearing me okay. Thumbs up.
I hear you. Yes, Your Honor.
Very good. You have to appear for all scheduled court proceedings. You have to notify pretrial services of any change of address, telephone number, or their contact information. You can't commit any crime during the period of release. You shall avoid all contact with the victim. And here is the victim is the paramour. And give me 1 second. Whose initials are BR. You shall report to pretrial services. I'm going to make it every week. You're going to contact them initially by telephone, and you can call them after 11 o'clock tomorrow. You'll get that information when I send the court order over to you. You shall refrain from possessing a firearm, destructive device, or other dangerous weapon. You shall refrain from excessive use of alcohol or any use of narcotics or other controlled substance without a prescription by a licensed medical practitioner. You're to abide by all family court orders, no contact with the victim. Again, that is BR for any reason. Now, look, sir, I can't tell you I'm doing this without concern, right? The police were there at your door. You didn't give them access. They had to go into the house to execute the, to serve the order. What I'm telling you is if there's any contact with the victim at all, because there is now, in addition to the order that the court is signing, there's now a restraining order in place. If there's any contact at all, you're going to get new charges. The state is going to move to detain you again. And if you're detained, let me tell you something. With the coronavirus and all these other issues, it's going to be some time before your matter ultimately gets reached for trial or disposition. You don't want to have that happen. I'm not saying that to scare you. I'm telling you that please abide by this court's order until further order of the court, okay?
I understand, Your Honor, and trust me, I will not contact my son's mother.
All right, well, that also means unfortunately your son, because if that's the only
And
contact.
not talk to my son or his mother. I understand.
Yeah, until, look, you are going to have the right to appear at that final restraining order hearing. And I don't know what's going to happen there. You'll tell your side of the story. But when that happens, one of the things that is going to be adjusted one way or the other, it may remain the same, is going to be custody. Just understand that. So you're going to want to make sure you don't absent yourself from that proceeding because that's important. Okay, do we know the next court date on this?
May 7th, Your Honor.
Your next court date will be May 7th, and that's going to be before Judge Levin.
Correct.
May 7th is your next court date here before Judge Levin, but we're going to have to see how this emergency situation pans out to see if that's a realistic date, all right?
Yes, Your Honor.
You get a copy of the court orders sometime today, all right?
Judge, if I may, we're going to schedule that before Judge Gibson on May 7th.
I'm sorry, Judge Gibson on May 7th.
Thank you.
All right, thank you. All right, take care, everybody.
Thank you, Judge.
Thank you.
Thank you, Roddy. Thank you, Your Honor.
You did orders yet, or how are we doing that? Have you prepared them yet?
No.
Yeah, so they're gonna, I just did them in pencil, you're gonna have to fill them out. David, for
5 seconds.
Thank you, Judge.
Okay, Jason, thank you for your help.
It worked a little different, but it did work.
You know, sometimes it's just all about winging it.
That's it.
You did a nice job on your end. Thank you.
Thank you.
I mean, we're not going to be able to expect everybody to be as up to speed on this